Okay, so we can get started today. Thank you everyone for joining us today. My name is Jay Huang and I am a senior associate at Scott Legal PC. So today we're going to spend some time talking about a variety of visa options available for investors and entrepreneurs. So just a few housekeeping items before we get started. Some of you may know that our firm, Scott Legal, was founded on an E2 visa several years ago. The founder of the firm is actually in the United States on an E2 visa and actually also have been on several different visas, including F1 visa, TN visa, B visa, and H1B visa. As such, we know what you are going through in a deep way. The firm, Scott Legal, is a full service immigration law firm, and we do offer immigration law legal services in a number of different areas, including E2, E1, TN, L1, family-based immigration, national interest waiver green cards, EB5 investor green cards, extraordinary ability visas, such as EB1 green cards and O1 visas, and more. Now, we have processed hundreds of E2 visas, and we typically process E2 visas that are considered higher risk, including those with lower investment amounts. And we have processed at consulates around the world, and our primary two consulates are Toronto and London. So we will be continuing this webinar series, and we are doing at least two webinars a week on different immigration law related topics. And at the end of this webinar, we will be sending out a few things to all participants for your benefit. First, we will send you a copy of this PowerPoint that we will go through today. We will also send you a link where you can download guides that go through these visa options in more detail. We will also send you a link that you can follow where you can sign up for additional webinars that are coming up in the future. And also this webinar itself will be recorded and will be made available on YouTube. We will also send you the link for that. And we do encourage you to subscribe and hit the notification button for our channel, as we do regularly upload a variety of immigration law related videos. Finally, we will also send you a link that you can follow to set up a consultation should you wish to discuss your case in further detail. So today we're very lucky to have Kelly Wiener, a partner of Scott Legal PC, to present today, who has extensive experience in processing a wide variety of visa petitions for investors and entrepreneurs. Finally, for any questions you may have, please feel free to add them to the chat box or the Q&A box, and we will try and get to all questions. So without further delay, let us get started with the webinar, and I will begin the presentation. So the first visa option that we're going to go over is the E2 visa. So let's go through the requirements of an E2 visa. So as a general matter, the E2 visa is a visa available for foreign nationals who are nationals of a treaty country, which are, a list of countries that have signed an economic cooperation treaty with the United States. And if you're a national of those countries, and if you're coming to the United States to develop and direct an enterprise in the United States, this is a visa option that could be available to you. So let's go through the requirements. The first requirement is that you must be a national of a treaty country. So there are around 80 countries that are part of the list of treaty countries that have signed such an economic cooperation treaty with the United States. And you can look this up by Googling, treaty country Department of State, and you can take a look at the list there. And certain countries are, sometimes added to the list, removed from the list based on, certain changes in those types of relationships. So definitely check the most recent version of such a list when you're considering this visa. The other important requirement is that the applicant must make an investment. So what does an investment mean? Making an investment means that you yourself are putting money at risk towards, purchasing an enterprise or setting up a new enterprise in the United States. So funds being placed at risk means either that the money was actually spent on things such as if you are setting up a new enterprise, if you have actually spent money on purchasing equipment for that business, or if you spent money towards securing business premises for your office, for your new business. Those concrete expenditures will be considered as money actually spent and thus funds being placed at risk. By contrast, a common question that we get is it enough if I transferred, let's say, $100,000 from my personal bank account to a, bank account under the name of my LLC? If you just transfer the money and if the money is just sitting there, can this be enough to prove that I have invested money into a business? And unfortunately, the answer to that question is no, because it is very easy to actually transfer back any of the money that you've placed in the bank account of an LLC that you own, back to your, personal account. So if the money hasn't been spent on concrete things and it is just sitting in a bank account, in the context of, you setting up a new enterprise in the United States, that will likely not be considered as funds placed at risk. So when we speak of investments, we are referring to funds being placed at risk. So one exception to that is in the context of when you are purchasing a business of in the United States. So what you can do in that case is that sometimes the buyer and seller can enter into what is called an escrow arrangement, where if the only condition for the release of the purchase funds is the approval of the E2 visa, you can actually use that kind of arrangement to effectuate the purchase, and that will still be considered funds placed at risk. But it is very important to note that the only condition for the release of the purchase funds must be the approval of the E2 visa. So if there are any other conditions to the sale of the business other than the approval of the E2 visa, that will still not be considered funds placed at risk. So it is very important to have your attorney review the purchase agreement and escrow agreement and things like that to make sure that you're meeting the requirements of your investment being placed at risk. All right. So the other thing to note is the source of funds. The government will ask, what was the source of the funds that you used to make this investment? And any legitimate source can really work. What the government is really looking for is, has, the money been, sourced from lawful activity, right? So things can be like personal savings from your employment income over the past few years. So in that case, you would provide evidence such as your tax returns that you have earned that money from your personal employment. You can also use things like a gift from a family member or someone like that. To serve as the source. But in that case, you want to go one step further and also show the government where the person who gave you the gift earned that money from. So the source of funds analysis will extend to the source of the funds gifted. So let's say, you received a gift from, your friend, and your friend in turn earned that money from, the sale of a house. Then you would, provide a copy of the purchase sale agreement for the house and the trail of the money from the sale to being gifted to you. So you would clarify where the money came from when you are presenting evidence of the investment. Um, Loans. So you can also use loans as source of funds for your investment. Now, the one thing you want to be careful about using loans is that you can use loans that are not secured by anything, such as, a personal line of credit or something like that, or a loan that is taken against secured against your personal property that is not related to the E2 business. But you're not allowed to use loans for the source of the investment if the loan is secured against the assets of the E2 business or, the E2 business itself. So be very careful to use loans that are, if they are secured against assets that are not related at all to the E2 business. The other requirement for the investment is that it must be substantial. And what does substantial mean? And we will go into a little bit more detail on the next slide. But basically, the government is looking for kind of a sizable commitment to setting up an enterprise or purchasing an enterprise. And so the amount must be enough to basically have everything set up into place that is necessary for the business to open its doors. So a too low of an amount will not be enough to satisfy that requirement of substantiality. There is no hard and fast minimum in the law of, a minimum investment amount. However, we do, have rules of thumb on, generally what amount of um, evid the amount of investment that consulates like to see. And also what's important is that different consulates around the world have different standards on the dollar amount that they expect to see when they are adjudicating E2 visas. So it is very important to also take note of those nuances. So when we're speaking of E2 expenditures, what kinds of things are we talking about when you're, making those purchases towards setting up a new business? So when we are preparing an E2 application, we see clients spending money on things like inventory, equipment, setting up a business website, payment towards securing the office lease if it is a business that has products. Maybe you would need a warehouse to store those products or equipment. So money spent towards setting that up would count. Things like spending on marketing and also legal fees that are related to setting up the business entity. All of those expenditures can be taken as a valid part of, expenditures made towards establishing a business for E2 purposes. So again, the distinction between starting a business versus purchasing a business for the E2 visa, you can choose either option. You can either purchase a majority interest in an existing U.S. business, or you can create a new business enterprise in the United States for the purpose of the E2 visa. And when we speak of investment, when you're starting a new business, we are speaking of money that was actually spent on concrete things that are related to getting the business to the shape that it is ready to open its doors. And purchasing things like inventory, equipment, website, things like that. On the other hand, if you're purchasing an existing U.S. enterprise, an option you do have to prove that you have money placed at risk is to use an escrow arrangement with the seller of the business, where the sole condition of the release of the purchase funds will be the approval of the E2 visa. So if you use an arrangement like that, you won't need to go forward with the purchase if the E2 visa is denied. And that can be one way to hedge the risks if you're making the investment. However, it is very important that the only condition for the release of the funds must be the approval of the E2 visa. Now, the other requirement for the E2 visa is that the business cannot be marginal. So marginality means that the profit generation potential of the business must be greater than what is needed to just support one person, the investor, and the livelihood of the investor's family. So what that usually means is that the business must be operating at a scale that would require hiring other U.S. employees than the investor. So it is important when you're setting up a new business to present a strong business plan that will describe exactly what is the revenue generation potential of that business and how many employees you will hire to support the operations of that business. And if you're purchasing an existing U.S. business, the same requirements apply. So if the purchased U.S. business already has U.S. employees, then you can show proof of employees to show that the business is not a marginal one. If the purchase business is not doing so well or has a low number of employees, you can also provide, concrete plans on how you plan to expand this business such that you will be, maintaining US employees. And our recommendation, kind of as a rule of thumb, is to plan to at least hire 3 to 4 full-time US employees by year 5 of operations of the business if you are setting up a new one. You don't need to have already hired the employee by the time you apply, but the plan must be that an employee will be hired once you start launching and operating your business. Another related and similar requirement here is that the business must be real and operating. It must not be an idle investment or a paper, business, something like that. By that, we mean the business is everything that is ready for that is necessary for the business to open its doors must have been procured by the time you apply for the visa. The business can already be taking revenue or very, very close to start operating after the E2 visa is granted. So after the E2 visa is approved, you can, come to the United States and start operating the business. So things like concrete steps such as having already signed a commercial lease for your office space is important. The business entity must already have been established. The company website must already have been set up. And if you can show that there are already contracts with customers that can be positive towards proving real and operating, or even letters of intent from clients who wish to hire your services. If any licenses are required, for your business to operate in a particular field, the government will expect to see that the licenses have already been acquired at the time you apply for the visa. Some other requirements for the E2 visa, you must be coming in to develop and direct the E2 enterprise. And so when you come into the United States on an E2 visa, you will only be working for that particular E2 enterprise that you were granted the E2 visa under. You can't just start working for other companies or be employed by unrelated entities to the E2 enterprise. So definitely the work authorization is limited to the particular enterprise that you apply for the E2 visa for. Ownership. So in order to qualify as a treaty investor, you must own at least 50% of the E2 company. And it is also important to maintain that majority ownership after you come to the United States on the E2 visa to make sure that the E2 status continues to be valid. Finally, you must show that you have intent to return to your home country after the expiration of the E2 visa. The E2 visa is not an immigrant visa, it is a non-immigrant visa, where you must show that your intent to remain in the United States is temporary. So that is another requirement of the E2 visa. All right, so let's talk a little bit in more detail about substantiality. So how much investment is enough? Now, there is no minimum dollar amount that is set in the regulation or the law. The government is looking for a substantial investment. And in some circumstances, in some types of businesses, the investment can be as low as 50,000 or less. And this also depends on the venue of where you are applying. Really depends on the type of business. So, for example, if you are setting up a service-based business, for example, a consultancy, like an accounting firm or something like that, where maybe you just need a laptop and, maybe you need some software, maybe, one employee or two to provide services. You don't need, you don't need a huge office space or you don't need a huge, set of equipment to do things like that. In that kind of case, the government will be more amenable to, finding that a lower dollar amount of the total investment can make sense, can still provide everything that is necessary for the business to open its doors. By contrast, let's think about other types of businesses, such as a restaurant, for example, where you would need a substantial space for the business. to be set up, substantial equipment, such as, expensive heavy equipment, regarding the kitchen equipment, and things like that. Um, and in setting up that kind of business or purchasing that kind of business, uh, because of the nature of the business itself, the officer would likely expect a higher investment amount to be for the investment to be considered substantial. So definitely, the important consideration here is the type of business. Um, Also, the amount substantiality inquiry will depend on where you apply and the examiner that is looking at your case. So, in some consulates around the world, some consulates are really used to seeing much larger companies applying for E2 visas. So, in that case, in certain consulates, any investment that is lower than $100,000, for example, would likely not be seen as substantial. Whereas in other parts of the world, where the consular officer is used to seeing smaller businesses applying for the E2 visa, you could maybe, get an approval with a lower amount. So definitely talk to your lawyer because there are nuances to take into account when you're calculating how much you will invest. Another thing to note is when you are applying for a change of status to E2 status through USCIS, for example, typically you may be able to apply with a lower investment amount through USCIS when you're applying when you're choosing to apply within the United States. However, in that case, the source of funds inquiry will be a lot more complicated. So there are definitely strategic considerations to take in mind. Finally, the overall strength of your case would inform the substantiality inquiry. So let's say you're only putting in, 60,000, to set up a service-based business. But what if you already have clients? And what if you can already show that you have revenue that is coming in, showing that the business actually is operational, and maybe you already have an employee who, you know, is providing services to these clients. In that kind of case, even if your investment amount is a bit lower, the other parts of your case, such as marginality and real and operating, could be very compelling, and thus maybe could prove as mitigating factors for a lower investment amount in terms of absolute money amount. So when the government is looking at substantiality, they will use what is called a proportionality test for a startup. And the government will compare how much money you have actually invested versus what are the usual costs to establish that business. So for any smaller enterprises where it is if the business itself is under 300,000 of value, you would likely want to show that you have invested 100% of everything that is necessary to set up a business like that to get it to the place where it is ready to be operational. Finally, another note is that franchises can be a good option for E2 visas, and we do see this as a choice that is pretty common. One thing that is good about a franchise is that the franchisor may provide, a variety of resources that can help you get your business afloat, such as marketing help or, existing goodwill in terms of the brand, things like that. So it can be helpful towards meeting, the marginality and real and operating requirements, and also any money that you pay to the franchise to, get the franchise rights and things like that can be included in the investment amount when you are presenting the case to the consulate. All right, so let's talk a little bit about employees. A very common question we get, do I need to hire US employees if I am applying for an E2 visa? And the answer to that is yes. And because this goes directly to the marginality requirement, the E2 visa really is not suitable if the business is going to be kind of a one-person shop, where if you're coming in as an individual self-employed person and you're not going to hire any employees to do the work in the business, The E2 visa will not be the best because the marginality requirement is directly related to the business's ability to hire and maintain U.S. jobs. So you don't need to already have the US employees if you're setting up a startup and at the time you are applying for the E2 visa, but you must be able to convince the consular officer that your E2 business has either the present or future capacity to generate enough income to provide more than a minimal living for you and your family, and thus be able to support US jobs. So ideally, we would recommend, demonstrating in the business plan or otherwise that your E2 enterprise will be hiring at least 3 to 4 full-time employees within the next 5 years. And so it is very important to carefully craft a business plan as part of a compelling E2 application. If you are setting up a new business, definitely the business plan will be the strongest evidence for meeting the marginality requirement. If you are purchasing an existing business, you may not need a business plan depending on how well the purchase business is doing. So for example, if the purchase business already has dozens of US employees, and if you can show that through things like W-2 records or current payroll and things like that, you may not need as a robust business plan to support the future income and hiring potential of the enterprise. But if you purchase a business that is not doing so well, and has a lot fewer employees, and if you're trying to show that you will be doing, additional things to expand the business to have this stable, hiring potential, then it may be a good idea to have a business plan where you can provide the reasonings of how you will make that happen. So in addition to the business plan, what can be helpful to support marginality is if you can provide client contracts to show demand for your work in the United States, or letters of intent from, clients who wish to hire the company for products or services once the E2 visa is approved. That can be very helpful in providing a little bit extra corroboration of the business plans to meet the marginality requirement. All right, so let's shift gears a little bit and talk about the EB2 National Interest Waiver Green Card, which also can be a good option for investors and entrepreneurs. Now, what is different from the EB2 NIW, how it is different from the E2 visa that I just discussed is that the NIW is a green card pathway. And that means, it's for US permanent residency. Now, where I see this a lot is sometimes you would come into the United States on an E2 visa or, some other visa, and you may be looking for ways to transition to, permanent residency in the United States. And in some circumstances, the EB2 NIW can be a good option for entrepreneurs because this option does not require a third party US company to give the person a job offer and go through what is called a labor certification, which is, the requirement to test the labor market to see if there is another US person who is able and willing to take the job before, a foreign national can be eligible for a green card. Now, for the EB2 NIW, if your case meets the requirements, you don't need that US job offer from a different company. And this can be very important for entrepreneurs because often entrepreneurs cannot avail themselves of the traditional job offer and labor certification requirement because for that you need a third party company to sponsor you. So let's go through the requirements for the EB2 NIW green card. So in order to qualify under the EB2 NIW, there are two considerations you want to be thinking of. The first is, do you meet the threshold requirement for the EB2 category? And there are three ways to meet the threshold requirement. The first way is to show that you have an advanced degree, which is defined as a master's degree or above. So let's say you're an entrepreneur and you have an MBA. You will be able to qualify for the EB2 threshold by showing that you have a master's level degree. And if you have an MBA from a international institution that is not a US college, US university, then you do need to also provide what is called a US education equivalency assessment report that confirms that your foreign degree is equivalent to a master's level degree according to the US system. Now, what if you don't have a master's degree or above? If you have a bachelor's degree in your field, and if you have 5 or more years of progressive work experience in your field, you can also be considered the equivalent of an advanced degree holder. So let's say you're, I don't know, an engineer and you have a bachelor's degree in engineering. And after you receive your bachelor's degree in engineering, let's say you've worked for 5 full-time years at a company, and during the 5 years, your duties have changed um, from junior to more senior duties. So it is important to note here that when we talk about 5 years of experience, we're not talking about 5 years of experience where your duties and responsibilities stay the same. We're looking for an upward change, an upward trajectory in your job duties and maybe your title, maybe your salary, things like that, to show that the experience was progressive. And if you can show that through detailed letters from previous employers describing how long you worked and how your duties changed, then you will be able to meet the advanced degree threshold, by being equivalent of a master's degree holder or above. Now, exceptional ability is an alternative way you can meet the EB2 threshold. And if in order to be considered someone of exceptional ability, you need to provide at least 3 out of the 7 evidences that is listed in the USCIS policy manual. Um, it includes things like, 10 years of experience in your field, evidence of having recognition for your outstanding achievements in the field by, um, professional associations, government associations, or your peers, which can be proven by expert letters or things like that. But what you really need to prove when you say that you're an individual of exceptional ability is that you're someone who is operating at a level that is significantly above what is ordinarily encountered in the field. And so if you can provide enough evidence of that kind of distinction, then you may not need to provide, the copy of the advanced degree or show a bachelor's degree plus 5 years. You won't even need to do that if you can show through other evidence that you are an individual of exceptional ability. So once you meet the threshold requirement, the other part of NIW eligibility is can your particular endeavor in the United States be considered something of national interest? So it is important to note that the green card pathway through the NIW is quite, a privilege. And the government gives that because they judge that your presence will be in the national interest compared to, the normal ordinary considerations of protecting the labor supply of the United States. So how do you prove that you're, getting a green card for you will be in the national interest? 3 criterias under a matter of Danazar. The first requirement is that your proposed endeavor must have substantial merit and be of national importance. And substantial merit and national importance can be shown in a wide variety of ways. And we do have specialized webinars on this topic. So if this is something of interest, definitely check out our other resources. But it can be through, things like a very significant number of jobs, and especially in an economically depressed region. And we're talking about dozens, hundreds of jobs that can readily be, taken as substantial with regards to the population and economic context of that particular region. So economic impact, or you can also provide evidence of benefit to the community as a whole. So what if you are developing a new treatment for a disease, if you're a medical professional and you're doing some research, and once this solution is commercialized, it will save the lives of tens and thousands of people in the United States who are suffering from this disease. So things like that, really the public interest, broad benefits to welfare, things like that can be very positive to meet the national importance requirement. And after the matter of Dinosaur test, geographical scope of a person's endeavor is no longer a consideration. So an endeavor can be based in one location. Let's say you're setting up a veterans welfare facility in a particular area of the United States, and you're, the impact of your work, is benefiting tens of thousands of veterans in that particular area. Even if your business is just based in that one location, you can still qualify as, a project of national importance because geographical scope of your work is no longer the consideration. Expert letters can be very important to provide the right context and detail on, which can really persuade the government of why this work has broader benefits than just serving your immediate clients or customers. Really, the broader benefit to social welfare or, technological advancement or just impacting the field in some way that is broader than just generating profit is what the government is looking for. The second criteria is that the entrepreneur must be well positioned to advance the proposed endeavor. And the focus of this inquiry is on the individual. So the individual applicants, education, professional experience, and portfolio of past projects that they've done that have produced, a positive impact. Those kinds of past record of success is what the government is looking for to ask themselves, this project sounds really great, but is the applicant the right person to drive forward this project? Finally, the third requirement is that on balance, the file must show that on balance, it will be more beneficial for the government to waive the labor certification process for this particular case and for this particular applicant, as opposed to, keeping the ordinary benefits of, saving one job spot for one U.S. worker, and really the ordinary benefits of a labor certification, which protects the U.S. labor market and by prioritizing U.S. workers. So, in general, for the EB2 NIW, definitely not an easy green card pathway, but can be a viable pathway towards entrepreneurs who can otherwise show that their business will have a broader impact to their field, broader benefits to societal welfare, or a significant economic benefit to a particular region. Really very fact-specific inquiry and takes a lot of advocacy. So get in touch with us if you think this can be an option for your particular business. All right, so now then I will turn it over to Kelly, who will take us through some other options for potentially for investors and entrepreneurs.
Thank you, GA. So we're going to talk a little bit right now about the EB1A, which is also called the Extraordinary Ability Green Card. So this is a green card that's available to people who have risen to the very top of their field and can show that they've achieved sustained national or international acclaim. So, there's kind of two ways to meet this. One is through one major achievement, like a Pulitzer Prize, a Nobel Prize. We haven't listed that here because by and large, for our clients and for most people applying for this type of visa, they're going to qualify based on meeting at least three of the requirements listed here. And we've highlighted the ones that are often very relevant to investors and entrepreneurs, right? So evidence you've been asked to judge the work of others. Very often kind of high-level investors or entrepreneurs might be asked to sit in on, like maybe competitions related to kind of investment or VC funding or accelerators that are very high ranked. Also evidence of original, business-related contributions of major significance to the field. Those are types of things that can be very helpful. Evidence of performance of a leading or critical role in distinguished organizations. So very often, if somebody's applying as an investor or entrepreneur in this category, they will have held very high roles, often at, major companies, either in the US or abroad. And, evidence you command a high salary or other significantly high remuneration in relation to others in your field. So they will look at kind of where are you working, what are the normal salaries in that field, and then what is your salary compared to that. Of course, any of the others that are relevant, like evidence of published material about you in professional or major trade publications, membership in associations in the field which demand outstanding achievements of their members. All of these would generally be relevant. Some of the others are, more focused on the arts because this green card is for people who can show extraordinary ability in the arts, education, business or athletics. So it's much broader than just for investors or entrepreneurs, but it has some very kind of good aspects to it. So one is you can self-petition. Often entrepreneurs are kind of shut out of the normal, green card sponsorship process because of their ownership in the company. So if they are someone who has had immense success in their field, this is something that can be very, a good option for them. GA has just walked us through kind of the national interest waiver. That's kind of another option that sometimes people will use if they have ownership in a company and want to be sponsored, but kind of can't use the normal labor certification process. Sometimes people that kind of have a profile that is not quite at the EB1A standard might consider the national interest waiver if kind of their company is or their endeavor is working on something that has substantial merit and national importance. But if perhaps the endeavor or what they're working on is not that developed yet, but they themselves and their own profile is, really exceptional in their field, then the EB1A might be more appropriate because the EB2 national interest waiver is going to focus more on the endeavor as kind of the main, piece of whether the petition will be successful, whereas the EB1A is really going to focus primarily on the individual and what has the individual accomplished. Can they demonstrate they have risen to the very top of their field? And there can be some benefits, in this category, which we'll talk about a little bit more on the next slide. All right, so this is kind of summarizing some of the benefits for the national interest waiver and the EB1A, both of which are green card categories that allow you to live and work in the United States, on a permanent basis. A really, positive aspect of these is you can self-petition for both. So in many, circumstances in green card situations, the applicant is kind of dependent on another person, in the family context, it's a family member sponsor. In the employment context, it's going to be, your employer sponsor, or, that can be something that's very attractive about these options is that, you have the control, you can self-petition and decide when to do that. It's a two-step process. So first, you're going to file Form I-140. That's where you prove that you meet all of these requirements. For the EB1A, it's going to be where you prove your extraordinary ability by showing you meet at least three of the factors, or at least one lifetime achievement. If it's the national interest waiver, you're going to show that you meet that threshold requirement of, master's or higher or equivalent or exceptional ability, and then that you have this endeavor that has substantial merit and national importance, that you yourself are well positioned to advance the endeavor, and that on balance, it's beneficial to waive the requirements of the labor certification. Then the second step is the green card part of the case. So the I-140 is where they're adjudicating, are you eligible for this criteria? And then the I-485, which is the form you'll file in the US, or consular processing, which is the process for getting a green card at a consulate abroad. That's where they're going to look at you individually and see, do you have, your biographical information, your address history, your immigration history, your criminal history. Is there anything in your history that makes you inadmissible or that makes it, so that you can't adjust your status in the United States, which is the process for getting a green card in the US. So that's kind of the process. Always important to consider, is there a backlog in the green card category? EB2 is backlogged worldwide, with then more extensive backlogs for people who are born in China or India. EB1 is not currently backlogged worldwide, but does have backlogs for people born in certain countries. So that's always something to consider in terms of, when do you want your green card? If you're going back and forth between the national interest waiver and the EB1, the EB1A, and kind of either one would work for you. Right now the EB1A is going to have less of a wait time, so that would be something to consider. If you're doing the process from within the United States, that's where you're filing Form I-485, an adjustment of status. You also can file Forms I-765 and I-131, and these are forms that allow for work authorization and travel authorization while you are waiting for your green card to be processed, because it can take, even up to or over a year for that I-485 to be adjudicated by, U.S. Citizenship and Immigration Services. If you're going through consular processing, so let's say let's say you're in the US even and you're working, your I-140 gets approved, but for whatever reason you prefer to go through consular processing, you will not be able to file the I-765 and the I-131. Having the approved I-140 by itself doesn't give you any ability to stay in the US. That's why many people, if they are in the US and they want to kind of stay here, they're going to file the I-485 and do the adjustment of status. Consular processing is a more appropriate process for people that who either are outside the U.S., so maybe they're not here, they don't have any type of short-term temporary visa status and not able to get one. So they'll process through the consulate where they, in the country where they live. Or sometimes, let's say maybe somebody is here on an E2 treaty investor visa and they need to travel a lot for work. Once you file your adjustment of status, you cannot travel on the E2 anymore. If you do so, you'll abandon your adjustment of status. And so for those people, they may prefer to consular process because the travel authorization applications are taking a very long time, several months. If they can't wait in the US, consular processing may be a better option for them. All right, let's talk a little bit about EB5. So EB5 can be another good option, for investors and entrepreneurs. You can either invest through a regional center, where the money is kind of going to the regional center to be deployed for certain projects, or you can make a direct investment, which is where you're starting kind of your own operation and making the investment, drafting a business plan, showing that it will meet all the EB5 requirements. So what are the EB5 requirements? So you have to invest either $800,000 or $1,050,000 into a new commercial enterprise. The defining factor of whether it's going to be the lower investment amount or the higher depends on whether the investment is in what's called a targeted employment area. So it's an area that has an unemployment rate that is 1.5 times the national average or a rural area. So there's very specific definitions for these, and you'll want to check that maybe before you if you're doing your own direct investment, for example, maybe you want to check that before you decide where you're setting up your operation. So, investment versus retained earnings, you cannot use retained earnings as investment. The money has to come from outside of the company. So that's something that people will often ask about. So challenges for EB5 direct investors. So the people who've done an E2 treaty investors may say, okay, I've done the source of funds requirement, it's fine. It's important to know that the EB5 source of funds requirement is vastly different than the E2, and it's extremely heightened in terms of the standard. Things that would be sufficient for an E2, perhaps you've sold a property and you're using that money, so you provide the purchase sale agreement and proof of you getting that money. For EB5, they're going to want to see things such as where did you get the money to purchase the property in the first place? Several years of tax returns for you and for any and all businesses that you own in and outside of the US. So it's a very, very deep dive into the financials of the investor, and you do need to be prepared for that. And also just consider that even if you've done an E2, things that were considered investment for the E2 may not be considered investment for the EB5. And even if you had a source of funds that was fine for the E2, that may not be fine for the EB5. So if you are doing an E2 with an eye to doing EB5 in the future, what you want to do is, start planning with your attorney at the start of the process, explain I'd like to do EB5 and set it up such that you can kind of maximize, your benefits there and make sure that later on in the process, you're not going back and saying, well, I didn't actually have a compliant source of funds. For equity investment, there's no ownership percentage. And the purchase has to be, equity. So you cannot have a loan as part of your investment, right? So this has to be kind of your equity going in. There can be no kind of guaranteed return on investment. The money does have to be at risk. Job creation. This is another very important requirement for EB5. So you have to show that the company will create 10 full-time jobs. If you're doing direct investment, then, that's, you're going to show W-2s, you're going to show, payroll summaries. If you're doing a regional center, sometimes you can kind of show this through indirect investment calculations, which will be done directly by the regional center. Um, you do have to, you do have to have a detailed business plan. So again, if you're doing a direct investment, that's something you'll have to provide. If you're working with a regional center, that's something that they will provide to you that outlines how they're going to meet the requirements. And there has to be a link, between your investment and the job creation. So that is very important. And you also need to make sure that you are documenting all of these full-time positions and the qualified workers. So that means meeting all compliance requirements in the United States, filling out I-9s, verifying that people are authorized to work in the US, because all of that will be required documentation that you'll need. When you are, later on in the process trying to remove the conditions on your green card. All right, let's talk about what an EB-5 filing looks like. So the first step is filing Form I-526. This is where you're going to show the source of your money and that you've actually made your investment. So if you're investing into a regional center, the source of the funds, the money going to the regional center. If it's a direct investment, the funds being transferred into the new commercial enterprise that you've set up. There is an ability now to, if it's current, to file an I-485 concurrently with the I-526. However, it will take a very long time to ultimately get the green card because the I-526, is taking about, 5 years generally, about 7 years for Chinese. I know people born in China, so there is quite a long wait. And the I-485 cannot be adjudicated until the I-526 is approved. So there are some benefits here. If you're in the US in a valid status and you file the I-526 and the I-485, you can also file for work and travel authorization. You can renew those indefinitely until you get a final decision, but you have to be prepared that you will be in limbo for, several years as you wait, for the government to adjudicate the I-526, and then after it's approved to adjudicate the I-485, which could still take several months or maybe even another year before you get that green card. Once you get your green card, it will be a 2-year green card. And at the end of the 2 years, in the 90-day window before it expires, you'll have to file a petition to remove the conditions on your green card. And that form is going to be the I-829. And that is also taking about maybe 4 years to be adjudicated. So it could be, at the end of that adjudication, you'll have a 10-year green card that's renewable indefinitely, or you can eventually become a US citizen. But again, you need to be kind of prepared that there will be, long periods of time where you're just waiting for the government to adjudicate, these petitions. All right, some other considerations, for EB-5. So, timing, I just talked a little bit about this. So about 5 years for the I-526, about 7 years if you're born in China, about 1 to 2 years for the I-485 or consular processing, and then maybe another 4 years for the I-829. So again, a multi-year process, that you need to be prepared for, if you're going this route. Country-specific quotas. So you want to check the visa bulletin to determine, what the availability is for the green cards in these categories. EB-5 is current for many categories right now, but not current for India, people born in India and China in the unreserved category. So, important to figure out, where you're going to deploy your funds and, whether or not there's going to be a delay based on where you're investing. So the investment has to be at risk. That means it has to be at risk of loss. And when we talk about, the intent to invest, the money has let's talk about two extremes. So there was one case in a court case called Matter of Ho. The person invested 500,000. They put it into a bank account. There were no commitments. Nothing was spent. And the court said this was not enough to show intent to invest. Instead, what you want to do is, if you're going to transfer the money into that account, some of it should be spent, and you should also have commitments. So signed contracts. There's no specific amount that has to be spent, but the more the better. Showing those binding contracts, showing money has been spent towards, investments that are going to, lead to job creation. All of that is important. You can't just put that money in a business bank account and, assume that will be, that will be sufficient. Um, For loans and gifts, these, are permitted, but you have to document the source of funds. Loans would have to be secured by the investor's personal assets. None of the debt can be secured by the new commercial enterprise. If you're going this route, you also have to make sure that if you're getting a gift, that the person who's gifting you the money is comfortable sharing all the financial documentation that will be required to fully document the source of funds. So kind of getting a gift doesn't, remove any of the requirement that you show where the money came from. That requirement is still there. And so you'll just need to talk to that person ahead of time before any money is transferred to make sure that they're comfortable, sharing all that documentation. Uh, Considerations when you're purchasing a business. So generally, you cannot purchase a business as an EB5 investment if the money is going directly to the seller because that isn't impacting job creation. So again, when we think about kind of E2 investors who are transitioning, we want to think about that because if you're purchasing a business, and you're paying money to a seller, you're not going to be able to use that for an EB5 investment. In terms of investment structure, how much to own, there is no ownership percentage. It can be a fraction of a percentage, so there's not that same requirement as with the E2 for 50%. In terms of guarantees, you can't have a guarantee. Unfortunately, you can't have a guaranteed return on investment. This would mean that your investment does not qualify under the EB5 requirements. And then in terms of differences from the E2, I think we've kind of covered this as I've been speaking, but essentially very different source of funds requirement, actual amounts that you have to invest, 800,000 or 1,050,000. So really quite different from the E2 in many important ways. All right, let's briefly talk about, in the last few minutes, let's briefly talk about some other options that we often see, as viable ones for investors or entrepreneurs. One is the L1A. So if somebody wants, to start up a new office in the United States, the L1A can be a good vehicle for this. There has to be a company abroad that has a qualifying relationship with a company in the US. So, parent, subsidiary, branch, or affiliate. The person who wants to transfer on the L1A has to have worked for the company abroad for at least 1 year out of the past 3 years in an executive, managerial, or specialized knowledge role. Generally, for an investor or entrepreneur, that's going to be an executive, maybe a managerial, depending on what the structure of the company is. There is no investment required for an L1A. So sometimes, if some people or companies have an option of an L or an E, sometimes they prefer the L because there's no investment required. That being said, if you're starting up a new office in the United States, there is a requirement that you show that the company will be able to kind of commence operations and kind of has enough working capital or cash at its disposal to kind of make it a viable enterprise that will be able to support an executive or managerial role within 1 year. So although there's no investment requirement the way there is within E2, very often, you do need to prove that there is some amount of cash that's been invested or is available to the company, to help it grow in that first year. So another potential, option is the international entrepreneur rule. This is very, very rarely used, partially because it's not a visa type. What you get is a grant for a period of authorized stay, also called parole. So it's a very discretionary, parole status, and there's very kind of specific requirements. The entrepreneurs, have to show that this was created within the last 5 years. There has to be potential for rapid growth and job creation by showing a certain amount, hundreds of thousands of dollars in qualified investments from qualifying investors. So this was kind of designed with the idea to allow for a status for people who had rapidly growing companies, where a lot of U.S. investors who were kind of established investors in the U.S. Were interested in helping this company grow rapidly, but it has not actually been used that frequently, partially because it has kind of very strict requirements and really would only apply to kind of a small subset of people. Um, Family-based options. So certainly, if an investor or entrepreneur is here and they, meet someone and they get married to a U.S. citizen or green card holder, they might be sponsored. or if they have other family members that could sponsor them. Diversity visa lottery, this is kind of a general option, but one that's, not closed out for investors or entrepreneurs. Something where you can, apply each year. If you're from one of the countries that's on the list, it is updated each year. So you want to make sure you're checking that. And then if you do get selected in the diversity visa lottery, the benefit is it's, quite, low standard to meet, to proceed with the application. You can't have any kind of inadmissibility factors, criminal issues. You have to show, you finished, high school or, 2 years of work experience. But overall, if you are selected, can be a good option. And then the E1 treaty trader visa. So this is based on kind of existing substantial trade between the U.S. and the treaty country. So it's similar to the E2, except it's based on trade. There's no requirement for substantial investment, but there does have to be substantial trade that is already in existence. So if there's kind of a pure startup situation, this often isn't going to work. But if you're in a situation where you have a company and they've been trading substantially with the United States as their main trading partner, showing at least 50% or higher trade, international trade with the United States, it can be a good option, particularly because you don't have to make an investment. You don't have to hire employees. There's no requirement even that you have a U.S. entity. Like let's say that you are importing or exporting, primarily from your home country, and you just want to be able to come to the U.S. to facilitate some of these, relationships with business partners. The E1 can be a good option for that. Trade can also be for goods or services. Sometimes people might start off with an E1 and maybe need to switch to an E2 if their entire operation becomes kind of a domestic U.S. operation. But this can be a good option, for some people, depending on their circumstance.
All right, so thanks so much, Kelly, for sharing your expertise. Let's see if we have any questions. I don't think I see any. So, yeah, I hope this session was helpful for everyone. Thank you, everyone, for your participation. Please stay tuned for the resources that we will send. And yeah, see everyone next time. Have a great day.
Thank you.